Good morning, Your Honors. May it please the Court, my name is Daniel Simon from the law firm of Lalcinani Simon. I'm here on behalf of the appellants. The issue that we're here to decide today, judges, is that whether the personal expenditure of legal fees and costs prior to and outside of the proceeding confer individuals with standing when those expenditures are made in order to fight a RICO scheme. This case, the plaintiffs at the initiation of the case are Mr. Helms and Mr. Rizzi, who own residential and business properties in the Marco Island area that include C5 zoned properties where they're allowed to run self-storage units. Other areas within the city are not allowed for that particular use. They fought for many years, as the record lays out, a scheme in which the city seemed to have support for the idea of allowing their particular use, the self-storage units, outside of the C5 area, specifically in C4, and specifically to the benefit of a set of citizens that owned a business that had different use.
Well, assuming your clients went out of pocket individually to fund this fight, the fact of the matter is the zoning classification has a direct impact on their companies, which are separate entities.
The zoning would have a direct impact on their companies, which are separate entities, but they personally spent money, which is the damages that are alleged. Right. Just to be clear, the damages that we're alleging are the expenditures, right, not the thing that didn't happen, right, which would be a change in zoning.
I guess more technically, as a matter of corporate law, I guess they could have made a loan to their companies, they could have made a capital contribution or whatever, but I guess these are small companies and they decided to go out of pocket personally.
Exactly, Judge. That's right. So
the companies also spent money, though, did they not?
They did.
So these individuals spent money who were the officers, directors, and shareholders, but the corporation all on the same cause of action.
Yes, exactly, Judge.
So it's not a separate injury they suffered, it's one and the same.
Well, it is the same scenario, but the injury is certainly separate. It's two completely separate pots of money. So just to make it simple, let's say Mr. Helms spent $25,000 and Mr. Rizzi personally spent $25,000. And let's say each of the companies spent $20,000. There's no doubt that the companies can't claim the $25,000 of the original and vice versa. The injuries here are certainly independent. And there are instances in which the RICO scheme did come across the individuals and target them personally as well, Judge, and this is pointed out in our brief.
Those are cases where, companies or entities targeted individuals for investments that ended up being, boondoggles and everything else, and they pursued them individually, then they formed companies, and then they pursued the companies, and then they could still continue to pursue the individuals. This doesn't seem to be a case where your clients were pursued in any way to do anything, because it seems to me that whether they decided to spend their own money or not and spend and unspend corporate money, they're still spending it for the same thing, as to stave off competition. Because they individually don't want competition, nor does their company individually want competition, because they're going to lose money. They lose money personally, they lose money corporately. What's the difference in the damages other than where the money came from?
Well,
it has to be separate and distinct. These are the two guys that own the two same companies, and they're basically trying to keep away storage business competition. So what's the difference?
Well, there are multiple instances in where they were personally targeted, Judge. There is the instance in which Mr. Kelly, who was the person who had an improper business relationship with Mr. Milk, personally came to Mr. Helms and offered to get him his money refunded, the money he personally spent, if he would simply allow the planned unit development change to go through.
But you have to go to him because he's the one that owns the company.
Yes, but the money that was suggested to be refunded was his personal expenditure, and so that would be money to him personally.
Yeah, but Kelly didn't care where the money came from.
Well, Kelly is...
you can't go to a corporation, can't talk. So, okay, Mr. Helms, I want your money.
What does it matter that
yeah, what does it matter?
No, what does it matter that Mr. Kelly... the fact is that Mr. Kelly was offering money to Mr. Helms personally in that
who owns the business? Who owns the business?
I don't think he can necessarily leap to the fact that when he has this conversation, he's talking that, yeah, I know you spent money personally, I'm going to give you back your money. as opposed to your company has been battling this zoning request and we're going to make your company whole.
Well, it's certainly how Mr. Helms testified about the interaction, and I think that would be a question of fact for the jury, Judge. The fact is that this man walked into his office and offered to refund him personally the money, and that's a question of fact that is disputed. Mr. Helms certainly received that in that way. And then the other instance in which Mr. Rizzi, during his deposition, testified that he had attempted on a number of occasions to buy more C5 properties outside of the business and was considering new ventures, and that on every instance he would go and speak to Mr. Milk about this and say, hey, I'm thinking about going to C5, and then another petition would come as part of the RICO scheme, and he would decide, you know what, I'm not going to go forward with that business. And it's clear from those interactions that there's a question for the jury is, hey, they're clearly targeting Mr. Rizzi and Mr. Helms to prevent them from starting additional ventures as well. And those ventures, it's undisputed in Mr. Rizzi's testimony, were not going to be part of the same business, or may have been new businesses or new entities or ones that he bought personally.
But
and
the
so,
sole thing you were seeking in this case is damages with the attorney's fees that were spent, right?
that is exactly right, Judge.
So I'm having a hard time understanding how that's a recoverable measure of damages based on the claims that you were bringing.
Well, the Begald case, Judge, cited in our brief, I think is one of the most helpful cases on that particular topic. It's a case that involves all the same causes of action we're bringing here, the RICO, FDUPTA, FCRCP. It is a real estate-related scheme that Judge Sleet was pointing out earlier, and they make it extremely clear that simply because someone is also a shareholder in the company doesn't mean that they don't have personal losses. And given that that's the fact, if you look at there's an extensive line of cases in these same causes of action, including the Sturge case.
These losses were incurred voluntarily.
Just as
They injected themselves into this dispute voluntarily, parted money voluntarily. When Judge Sleet correctly pointed out, the real way to have done it is made a loan to the corporation, et cetera, and they became volunteers in this venture.
Well, the people that made real estate investments were volunteers in the Begald case. They saw an opportunity and they expended money, and then later found out that the elements underlying the opportunity were a RICO scheme. And the same thing happened here. Mr. Helms and Mr. Rizzi chose, just as the people in all these cases chose, to part with their money, as Your Honor said, which the record shows that they did. They decided to step into the fray, and then later found out that the fray they stepped into was actually an ongoing RICO scheme.
Well, what do you say to the possibility that there was another motive based on the affidavit of Mr. Helms, who specifically said that since 2004 he has sought business from various departments of the city of Marco Island, and the city has never opted to store items at his business? What in the world does that have to do with this case other than a personal vendetta against the city? Because they will not store their stuff in his space, and they're storing it somewhere else. Why is he entitled to fees when he is fighting these zoning regulations for a personal reason because he's being denied business?
Well, first of all, none of the fees he's seeking are related to his attempts to get business.
Because his affidavit basically says this is one of the reasons I'm fighting this.
Well, that element, Judge, is an important fact for the jury, because it came out in the testimony of the other witnesses, including Mr. Milk, that the city was actually storing its stuff improperly at these C4 buildings that were owned by the other defendants, specifically the Kellys. And so when Mr. Helms came out in his deposition and stated that he had gone to the city and tried to get their business, as any businessman would, later he finds out that the city was illegally using this as a storage unit.
Yeah, but he doesn't have a private cause of action for that city's conduct. He doesn't.
Well, that simply goes to the collusion between Mr. Milk and the Kellys, in that instead of using private businesses, they were using the city improperly in another element of the RICO scheme. There's not a direct request that, hey, I need the damages of what I would have rented. Rather, what he was pointing out was there were businesses soliciting the city. Instead, they were storing their items for free at this entity, which they had an improper business relationship with. The community affairs director, Mr. Milk, had this relationship with the city, and instead of utilizing businesses in the area that were properly zoned, the city was going to this improper use. And so it's simply illustrative of the actual scheme that was going on, Judge. It's not a request for damages, nor is he saying that his attorney's fees are related to that attempt to get business in any way.
Well, but his personal reasons of seeking business from the city and being denied or rejected, you would agree with me, that would defeat the wrongful act doctrine, would it not?
Not at all, Judge. No.
How so? Because the wrongful act doctrine is where a wrongful act of the defendant has involved the claimant in litigation with others and has placed the claimant in such a relation with others as to make it necessary for him to incur expenses. He has attested under oath that he has incurred expenses because he's been denied business.
Well, Judge,
and the reason you're giving me that he has been denied business is because they have improperly stored it in the C4 zone.
Judge, I mean, I think it's improper to take a single line from his affidavit in a substantial record and say this is the sole reason he entered into this litigation. He was simply pointing out a fact.
This statement has legal implications and ramifications.
But it doesn't erase the rest of the record, Judge. Well, he was pointing out a fact. He has approached the city. They did not store it with him. The rest of the record shows that, in fact, they were illegally storing it where storage is not allowed to take place. And just coincidentally, they were storing it with the businesses that it turned out had an improper relationship with the community affairs director. And the evidence shows that that relationship was one of the causes of that storage. I mean, it just goes to show that they had this improper scheme, and it also goes to show that Mr. Milk knew that they were not allowed to do storage and that they were doing storage, Judge. A lot of Mr. Milk's depositions and the other depositions have to do with the fact that at one point in time he was also in charge of inspections. And Mr. Helms and Rizzi believed, and their businesses believed, that these particular entities were secretly doing storage. They complained to the city. Mr. Milk carried out the inspections, cleared them, but then also testified, yes, they were storing the city's things there. And so it's very relevant to show the actual presence of the RICO scheme, that the city was doing the storage, Mr. Milk was doing the inspections, and yet clearing the city after the inspections.
But all the case law that you seem to cite, it demonstrates that the plaintiffs are targets. I don't see where your clients are targets of anything in this case. They've injected themselves into this litigation. They injected themselves into this zoning fight. How have they been targeted in any way?
Well,
explain to me, is there any other injury or harm in this case other than their expenditures of attorney's fees?
Judge, the only damages they're claiming is the expenditures of attorney's fees, and that's the exact damages that the companies are claiming as well, and those opposing counsel doesn't dispute that the companies would have standing based on those expenditures. What they're saying is because these individuals also own companies that were targeted by the RICO scheme, that would strip the individuals of their standing.
So your argument is, if I'm in a particular zone and you're in a particular zone where you have a business with air conditioning and I want to get a zoning for my particular C4 and I want air conditioning and I happen to know somebody in government and I call them and ask them to work on my behalf to do that, and you fight that process, the legal process of seeking redress from government, that in every case you have a cause of action for the expenditures of your fees for fighting my effort to get my zoning and my property?
Absolutely not, Judge. Only in a case where it turns out that there is a bribery scheme that is resulting in the city's repeated efforts on behalf of these private individuals.
Okay, so the expenditure to fight the zoning and having your lawyers show up for the hearings and all that, you're not seeking to recover.
No, yes, of course we are.
Well, you just told me that the only harm was really the being bribed.
No.
Which is it?
No, Judge. The thing they were fighting is the fruit of the RICO scheme. The RICO scheme was to have these repeated attempts at rezoning. There was an improper relationship between a city official and a business and business people that ran that business. That was the scheme that manifested itself in these repeated attempts. There was a situation where the city brought the petition in order to modify the zoning, and then at the hearing it was suddenly switched over to be a personal petition by Mr. Kelly. There were a number of instances where that coordination, and we have witnesses on the record saying this was extremely unusual and people were seeing this behavior. And then ultimately, when their relationship came out, Mr. Milk was terminated for this very reason, that he was having an improper relationship. And so Mr. Helms and Mr. Rizzi went through years of fighting this scheme without knowing that it existed. When it came out, all of a sudden they realized, oh, we were fighting a RICO scheme this entire time. And yes, at that point, their damages became recoverable in a RICO cause of action. Just like the people in the Begall case or the Mays case, Judge, which is an extremely helpful case from Judge Marcus in the 11th Circuit in 2001 that makes it very clear. None of those people knew a RICO scheme was going on. It's as though Your Honor is asking me, oh, so anytime you invest in real estate, that's recoverable. Of course not. Only when it turns out to be an illegal bribery scheme, which is the case here, Judge. This is not a situation where the plaintiffs are attempting to, chill legitimate use of the rezoning process or petitioning. But when it turns out that the fight you've been fighting for the last 5 years was actually aided by someone who's in business with the other business, and they are fired for that reason, and it has turned out to be an illegal relationship that's tantamount to bribery, then at that point, they said, we have spent all this money on this process, and it turns out we were fighting an unfair fight. There was a thumb on the scale of justice, and there was an inside man in the city that was helping them all along, advising them, telling us not to open our new businesses, having them repeatedly file these petitions, and it kept morphing year after year. Even though the board was rejecting it, it just kept coming back from the dead. As soon as they discovered this is all a RICO scheme, they then said, we have now been the victims of this scheme. Judge, I think the issue on standing, an easy way to think about it is that if those businesses didn't exist, and Mr. Helms and Mr. Rizzi are just people that own, residential and business properties in Marco Island, and are perhaps interested in opening further businesses down the road in the C5 zone, and they see people trying to modify the city plan, the agreed upon city plan about zoning, and they decide as concerned citizens to go in and fight it, and yes, they certainly have their interest in maintaining the city plan for various reasons. If they didn't have the two businesses, they would still have standing, Judge, because they expended their personal money. The Sturge case from the Southern District of Florida in 1992, the Handine case, the Stochastic case, the Berger case, all of those cases cited in our brief, Judge, make 100% clear that in these RICO and FDUPTA and FCRCP cases, the money you expend outside of the proceeding, just like in the Wrongful Act Doctrine, are recoverable damages.
Mr. Simon, let me interrupt you for a moment. You're up to 18 minutes.
I'll save the last two for rebuttal, Judge. Thank you very much.
Great. Thank you, sir.
Good morning, Matt DeVries on behalf of Michael Kelly, Lisa Kelly, Progressive Auto Management, Progressive Auto Center, and BML LLC.
Are both of you going to be arguing?
I would like to reserve 15 minutes and have Mr. Wood set aside 5 minutes for Mr. Woods.
15, 5? Yes. Okay, very well. Go ahead.
Can I ask you a question right off the bat?
Absolutely.
I'm troubled by this. The trial court denied motion for leave to add the corporate parties, but at the same time didn't find that the individual parties had standing. Help me reconcile that apparent conflict. I don't understand why that could happen. If the court basically says, you don't have standing because you're individuals, but you guys, well, you probably the ones that have standing, we're not going to let you be added as parties. Help me figure that out.
Absolutely. A few procedural points. The motion was filed about 5 days before the hearing, and the court specifically found at the hearing that it was not set for hearing. So
what's your prejudice? I know you cited that in your brief, but what's the prejudice really?
Your Honor, it would be the Corrigan case from this court in 2016. It stands for the proposition that a party must have standing at the time the complaint was filed. So the court cannot grant that motion and retroactively add the parties and add standing at that point. The corporations had to be parties at the time the initial lawsuit was filed. because standing has to exist at the time the initial complaint was filed.
Yeah, but they can be substituted as parties. You can add parties
But
under 1.210.
again, the Corrigan case stands for the proposition and states the principle of law that a substituted party only retains the standing of the original party. Because the original individuals did not have standing, even if the parties were substituted in, they cannot obtain the standing of the individuals. It had to be the corporations. Those are the true parties in interest.
All right, well, let me ask you this. If we affirm this, are you going to argue res judicata in the other litigation?
With respect to standing of the corporations,
Yes.
Your Honor, we would argue, as we have done throughout the briefs, that there are no recoverable damages under any of the causes
So
of
you're not going to argue res judicata? Because right now you're saying that they don't have standing as a full party here. They were allowed in as an intervener, and they're subordinate to the issues. So you're not going to argue in the other case that this affirmance here would be res judicata in the other case, are you? Because if you are, then you're basically saying they're parties here.
We would not, Your Honor. We would simply pursue the argument that we have in this appeal that there are no recoverable damages, even if it is the corporations.
It'd be hard to make that argument anyway, though, right? Because the reason why this court did it is because these potentially to be added parties did not have standing at inception because the other individuals did not. Whereas that issue's really not in play in this other lawsuit, right?
That's correct, Your Honor.
So, I mean, it'd be really easy to explain to that judge, well, this is the technicality upon which that decision was based, and that does not exist here, right?
Correct.
I want you to commit yourself on the record so we don't have any issue down the road.
Correct, Your Honor, but we will still pursue the other damages argument that there are no recoverable damages for any of the causes of action pled. Under RICO, the only request was for an injunction. The other two causes of action were for Civil Remedies Act and under FDUPTA. Under both of those statutes, actual damages are a necessary element.
And that's a totally separate issue, though, than what we're talking about, right? I mean, that's been the focus of your argument here. Those aren't recoverable damages, and that's going to be the focus of your argument there, but neither of those issues necessarily relate to the issue of standing, right? They relate to whether or not there's a cause of action.
To me, they're both related to standing. The first is who owns the causes of action, the individuals or the corporations. Under the Harris case...
Well, your position is neither of them.
That's correct, Your Honor. The individuals do not have standing because they did not own the property, as Judge Sleet recognized during opposing counsel's argument. The fundamental issue and the actual focus with respect to that issue of standing should be who was going to suffer the harm if the petition or variance was accepted by the zoning board. The entities owned the property in Marco Island, and they were the only ones that could have suffered any harm if this petition or variance had been accepted. The separate issue of standing relates to the recoverable damages. I see that as an issue of standing. Again, under FDUPTA, Civil Remedies Act, actual damages are a necessary element. It's the Rollins case from this court in 2006. Price versus Taylor, Supreme Court case 2004, says attorney's fees are not actual or compensatory damages. They're consequential damages.
Well, I don't want to get you too far off the field from this case. It seems to me those are causes of action. And I think where we're trying to get, and maybe we're not trying to get you, but it seems to me that if anybody had a cause of action, it would be the companies.
Absolutely correct, Your Honor.
Okay. So to the point, in the next case, certainly the companies might have standing, but what I hear you saying is under the statutory schemes, those attorney's fees are not recoverable.
Absolutely correct.
Okay.
Can I shift you to the cross-claim now? The anti-SLAPP argument that you've made?
Yes, Your Honor.
The action they brought is clearly not fall within the anti-SLAPP statute. There's no way is it a chilling effect on someone's effort to express their First Amendment rights. So help me understand why you think I'm wrong in what I just said, because I know you're going to say that.
Yes, Your Honor. I do think the anti-SLAPP statute applies. The basis of the lawsuit is, and there's deposition testimony in the record, that the purpose of opposing these zoning petitions was for a personal gain, for a personal benefit. Judge Sleet recognized it. It was actually to chill competition. They did not want this variance accepted because it was going to hurt their two businesses in this property in Marco Island. And the anti-SLAPP statute exists because a party should always be given the opportunity to exercise its constitutional right to petition the government and free speech. If this court were to make a ruling that a party could obtain their attorney's fees and costs in subsequent litigation for challenging a zoning petition, that absolutely would have a chilling effect on people and businesses that own property, and they potentially go see their attorney and say, you can pursue this zoning petition if another party challenges it, and in the end they make some wild claim that this was all a RICO scheme. You could be subject to paying their attorneys.
What's the closest case you could find factually to this situation that will give you comfort in relying on it? I couldn't find any.
The most recent case that I could find that discusses the anti-SLAPP statute is an opinion from Your Honor, Judge Morris, the Gundell case. The opinion was issued February 1st, 2019. And that case, it involved members of a homeowners association and a developer. And the members of the homeowners association were making claims and complaints about dues, and the developer, and making public comments about that, the developer filed a counterclaim against the members of the homeowners association. The homeowners association filed a motion for judgment on the pleadings, motion for summary judgment under the anti-SLAPP statute. This court accepted jurisdiction on a petition for writ of certiorari and issued an opinion reversing an order denying the motion for summary judgment.
Those facts are very, very far afield from these facts.
I think they can be analogous. They're certainly different. That is the most recent case and likely the most similar case I have with respect to whether the anti-SLAPP statute does or does not apply in this instance. I do think absolutely there would be a chilling effect if this court issues an opinion that says a party can get their attorney's fees and costs opposing a proper, completely proper zoning petition.
Did you raise the SLAPP issue below?
Absolutely, in our affirmative defenses, Your Honor. It's affirmative defenses 9 through 12. It was raised in the pleadings and in the affirmative defenses, and that's clearly sufficient notice. With one other issue on appeal is the wrongful act doctrine. There's been discussion that the wrongful act doctrine applies. It was actually raised sua sponte by the judge at the hearing on the motion for summary judgment on damages. The wrongful act doctrine was explained by this court in 2012. It's the Rose-Edier case. The wrongful act doctrine is a very limited exception to the American rule, which, as the court knows, holds that attorney's fees and costs are only recoverable if there's a contract or statute that provides for their recovery. The wrongful act doctrine applies when a wrongful act causes a party to litigate against a third party because of that wrongful act. So, two reasons in this case why the wrongful act doctrine does not apply. First, there was no wrongful act, and this goes directly to the anti-SLAPP argument. It is not improper in any way for a party to seek a zoning petition or variance to exercise their constitutional right.
Yeah, but aren't they arguing that all this other stuff involved in the improprieties among the city official and them and you and all that is really what the wrongful act is about?
And I would point the court to the deposition testimony of Mr. Helms and Mr. Rizzi, which says that the real purpose of challenging these zoning petitions and variances was because it was going to hurt their businesses and it was going to hurt them economically and financially.
Well, what I take from their position is they felt they had to take the action they took because there was skullduggery going on at City Hall.
Actually,
And they said that we ain't getting a fair hearing here. This is an inside game, and we don't have a ticket. That's what I get from, their lawsuit. So it's a little different than just a straight-up challenge to a zoning. We're challenging this because something ugly is going on at City Hall.
actually, opposing counsel mentioned during his argument that they didn't even know that a RICO Act was occurring during the relevant time period, and they only found out afterward. And then they they filed this lawsuit. And if you look at the record facts, Mr. Milk, who they're saying was the bad actor or engaging in this corrupt behavior, was fired January 2014 from the city of Marco Island. They filed their lawsuit in 2016, so more than 2 years after he is fired. Their complaint seeks an injunction from stopping Mr. Milk from engaging in this alleged improper behavior when he doesn't work for the city of Marco Island anymore. So, and again, I would go back to the deposition testimony of the two individual plaintiffs in the record where they're saying, we were doing this for our own economic benefit, and we were doing this because if the zoning petitioner variance was accepted, it was going to hurt our businesses. That in no way can qualify as a wrongful act under the wrongful act doctrine to allow the plaintiffs to recover attorney's fees and costs from our clients. The second reason that the wrongful act doctrine does not apply, it only applies when there's litigation with a third party. It's undisputed on these facts that there was no litigation with a third party before the city. They certainly weren't litigating with the city. They were challenging the zoning petitions, which were submitted by Progressive. So that it's just undisputed that there was no litigation with a third party. A separate argument with respect to the wrongful act doctrine is that if you seek attorney's fees and costs under the wrongful act doctrine, you have to plead them as special damages. They are special damages. Rule 1.120G says special damages must be pled with specificity. It's undisputed on this record. Even after the court, Judge Hayes in Collier County raised the issue of the wrongful act doctrine sua sponte, the plaintiffs still did not include it in their pleadings, did not request it. And it's the Robbins case from the first DCA specifically says in that case they reversed an order awarding attorney's fees simply because the requests for attorney's fees under the wrongful act doctrine were not specifically pled. Separate and apart from that, under the wrongful act doctrine, the case law is clear that attorney's fees and costs under the wrongful act doctrine does not create an independent cause of action. It is simply allows you to recover attorney's fees if there already exist recoverable damages under a separate cause of action. In this case, and this is where I was going before with the Civil Remedies Act and FDUPTA, there are no recoverable damages in this case. Again, attorney's fees and costs, Price versus Taylor, Florida Supreme Court, are not actual or compensatory damages. They are consequential damages. The case law under FDUPTA is incredibly clear that consequential damages, lost profits, things of that nature are not recoverable under FDUPTA because they are not actual damages. Same thing with the Civil Remedies Act. The language of that statute actually says an aggrieved party can recover actual damages. That is not what we have here. We do not have actual damages. So under the Tipsy-Coachman doctrine, even if the court finds that the individual plaintiff somehow had standing, the court could still affirm and find that the plaintiffs have no recoverable damages under any of the causes of action pled.
You're at your 15 minutes.
Okay. Thank you very much.
Thank you.
Greg Woods on behalf of Bryan Milk, and to perhaps address the court's concern, we would not take, in the lawsuit that's been filed by the companies, we would certainly dispute their claims on the merits, but we would not reiterate that this case is in any way, this holding would be res judicata upon them.
Thank you.
As your honors have kind of pointed out, this case by Mr. Helms and Mr. Rizzi is really kind of a personal vendetta that they have pursued. They were not the targets of the RICO scheme. And there's no evidence showing them, record evidence, showing them to be the targets of the RICO scheme. They became mere volunteers. They voluntarily paid money, voluntarily paid attorney's fees, which I'm sure, as the court noted, the companies could treat as a loan, repay to them. Only one person or entity can own the cause of action. And here, the cause of action, if one, the cause of action is owned by the companies, not, you can't have a split cause of action just because you pay for attorney's fees along the way. You can't make yourself a voluntary plaintiff. You can't. They didn't buy themselves into this claim. So there's just nothing there that gives them standing.
The allegation that Mr. Milk approached them either in an effort to make a bribe or whatever however you want to describe it, but there's still an allegation that Mr. Milk approached them individually. So that appears to show that they are a target in some way of some type of nefarious act. Why doesn't that create an issue of fact here?
First of all, the court should look at the record on that, because that wasn't a part of the summary judgment hearing. It certainly wasn't raised as part of the, if you look at the transcript of the summary judgment hearing, there's no discussion,
no mention
of bribe, et cetera. And the record evidence with regard to that is woefully deficient. But think about it this way, too. If that even occurred, if there was a bribe, I think they phrased it in their motion for reconsideration as an attempted bribe. So it's an attempt at a bribe that wasn't accepted, no detail given, no action taken by them, no detriment to them. I mean, there's no harm or potential harm or damage to them as a result of that statement, if it occurred. But the record, first and foremost, the record's lacking on that. But even if it occurred, it's there's no harm. Unlike, at least, I guess in theory, they can contend that the companies would be damaged if the zoning variance occurred and they had competition. Then you could show some kind of harm. And even with regard to the fees incurred, when we get to the next case, when we go to the case against when the companies sue us, we're going to be fighting like heck that they voluntarily incurred attorney's fees. Those zoning boards, the zoning board and the city council may well have denied the variances for the same reason they did, without them having done anything, without them having expended a nickel. You could have had the same exact result from the zoning board and from the city commission. And so there was really no need for them to incur any expense and to try to bootstrap all this into a RICO claim after the fact just doesn't fly. Thank you.
Thank you.
Thank you, Your Honors. I know I have a couple of minutes left, so I'll try to be quick. The first issue was properly raised by Your Honors, which is that we also requested on 3 occasions that the intervening companies just simply be added as full parties, because opposing counsel, after the evidence came out that they had paid some of the money, were making this argument that, okay, they must be the ones withstanding and not the individuals. That is something that the Florida Supreme Court has been extremely clear on, should be liberally granted at any time. There's cases cited repeatedly where it's granted post-judgment, after statutes of limitations, and all kinds of extreme circumstances. And here, they should have simply been moved into the case if it's their argument that these are the substituted parties that are the true parties in interest related to these claims. In between the entry of the judgment and the motion for rehearing, we even filed another case in which they were the plaintiffs with an identical complaint and requested that they be consolidated, another motion that should always be liberally granted. The rehearing, the order denying it just was simply a one-word denial with no reasoning. One thing related to the wrongful act doctrine, opposing counsel pointed up that this was a doctrine brought up sua sponte by the court, was not argued by either party related to the initial summary judgment motion in the case, which was denied by Judge Hayes. There's no record of that argument in front of Your Honors. It was not in the briefs. The only place that the judge's reasoning exists is in the hearing transcript, was not presented to Your Honors in order for you to properly evaluate what happened. Yes, there are cases allowing orders denying or granting motions for summary judgment to be reviewed without a hearing transcript, but only in situations where the full arguments are relayed in the briefs. In this case, there was a sua sponte decision by the judge to invoke this wrongful act doctrine, and Your Honors can't properly review his decision without that transcript. Opposing counsel also stated on a number of occasions that they opposed the efforts of the RICO scheme in order to stop the variance, and that shows that they're only suing as a personal vendetta or whatever they're saying. The fact is that they did oppose the RICO scheme to stop the variance. If you'll read my client's depositions, it's 1,000% clear they thought something unfair was going on the whole time. They only sued when it came out that there was, in fact, actually a bribery scandal going on. So yes, the cause of action only ripened when evidence of this RICO scheme became a knowledge to the public. They learned that this hidden scheme existed. Mr. Milk was terminated, and the petition that was then in front of the city that had just been granted was quickly then reversed. And this happened, basically there was a petition that was favorable to Mr. Kelly. Mr. Milk was then fired. A couple weeks later, the city then reversed the petition. And so it is the issue that Mr. Woods brought up additionally, saying, well, you know, who knows, maybe these petitions would have been rejected even if my clients hadn't done anything about it. That's not an issue that's germane to any of the issues that are before the court today. The question for Your Honors is a question of standing, and a question of whether individuals who pay out funds and therefore have the type of damages that is mentioned in the Sturge case, the Handine case, the Stochadic case, the Berger case, as actual damages, they have the damages that it turns out were caused in fighting this RICO scheme, whether that confers standing on them in a case in order to fight the scheme. And even if it doesn't, judges, the proper outcome of the situation was simply to allow these two interveners, who were already members of the case, and by the way, it would not have required a single word to be changed in the complaint, because the complaint, the Second Amendment complaint that was currently in force, already listed the damages by the interveners as well.
Thank you.
Thank you, Judge.